Hello, and welcome to the interactive Vision and Victory Town Hall. Thanks for joining us. I'm your host, Bob Trent. Joining me in the studio today is Mike Ferris, President, CEO, and General Counsel of Alliance Defending Freedom, and Kristen Wagner, Senior Vice President of U.S. Legal Advocacy. This Town Hall series is part of an exclusive series of town halls focused on how Alliance Defending Freedom is pursuing victory in this cultural and political climate, and the vital role that you play in that pursuit. In the next hour, you'll hear from our attorneys and clients who are directly engaged in the battle to build freedom's future, and you'll have the opportunity to ask questions throughout the hour. In fact, if you have a question during the show, just press star 3 and you'll be directed to a representative. As a new day of opportunity dawns, thank you for standing with us. Now, Mike, you've led Alliance Defending Freedom for 5 months now. In the last town hall, you talked about what generational victory would look like. And we've taken up that challenge, been very busy the last few months, particularly in protecting the freedom of those who want to live and work consistent with their beliefs. And then also in colleges, we're really engaged to protect free speech and civil discourse on campus. And also, if that's not enough, this is really the end of the first fiscal year in which you've led Alliance Defending Freedom. So what do you look forward to in July and then beyond?
Well, Bob, I'm glad to be past the budget process, to tell you the truth. But we're really excited about what's going to be happening in this next year. A lot of great things are in store, particularly in the university context. As the listeners may know, I was at Patrick Henry College for 17 years before coming here. And so the college setting is something near and dear to my heart. And I just believe in a nutshell that unless we have free college campuses, we won't have a free country eventually. Because if you raise the future leaders of the country in an atmosphere where it's soft totalitarianism that's really in place, we're going to end up with probably worse than soft totalitarianism. It's just going to be straight up an abuse of freedom and an abuse of the rule of law. And so our university cases are near and dear to my heart, and they're exploding all over the map. We're having a great success rate thanks to Kristen and her team.
Mm-hmm. Absolutely. And actually, we'll have Casey Maddox on here shortly to talk about what the Center for Academic Freedom is doing. And Kristen, your team has had a really busy year as well. At the Supreme Court alone, you've had one case argued before the Supreme Court. There are 2 other cases that are pending acceptance by the court, and there are a number of appeals on the way. So really, where have you seen God move in the ministry this year in your efforts?
Well, as I was thinking about this, there are so many different areas, and I think I would start with something a little more fundamental, which is that we receive about 4,000 requests for help every year, and obviously most of those cases never make it to the Supreme Court. But our mission is to keep the door open for the gospel, so when we're able to help those people to engage in their ministry and be able to share the gospel at their level, that's a tremendous success, and we've had a lot of those this year. Keeping food banks open, keeping homeless shelters being able to share the gospel, Christian schools that are facing threats. Those are all the kinds of cases and matters that we get to deal with on a daily basis, and it's such a privilege to help those. As they say, politics is at the local level. Well, in many respects, so is sharing the gospel, right? So we're also privileged to play a role in the Supreme Court decisions and at the appellate level, and we have a great appellate team that's working on those cases. I would say Trinity Lutheran, which we'll talk a little bit about with Dave Cortman, who argued that case, is going to be a victory, and we're seeing great success in other areas too, including in our conscience areas. We had a win in Kentucky out of the Kentucky Court of Appeals involving a T-shirt printer that was literally faced with the choice of losing his entire business or printing a message that violated his religious convictions. And he won that case recently at the Court of Appeals. It'll go up potentially to the Kentucky Supreme Court, and we expect to prevail there. So there are a number of areas, and obviously on the university team. We've had a banner year in wins on our university team, and that's a success for all of us because free speech on campus matters to everyone. What happens on campus doesn't stay on campus.
That's a great point, and actually a perfect transition to our first segment here. Now, Kristen, thanks so much for that answer. Your team, again, has had a busy year. We're going to now switch to our first guest, Casey Maddox, Senior Counsel and Director of the Alliance Defending Freedom Center for Academic Freedom. He leads a team that boasts a win rate of nearly 90% in litigated cases. Now, as a reminder, if you'd like to ask a question to any of the attorneys appearing on the show right now, just dial *3. They'll put you through to a representative, they'll put you in the queue, and they'll put you through live on the air here in a question and answer period here shortly. So, Casey, thanks for joining us.
Hey, thanks for having me on.
Now, Casey, earlier this year, a group of students at a community college in Michigan were arrested for passing out copies of the Constitution. That doesn't seem possible to me, but I know that you're litigating the case and know that that's true. Now, colleges and universities are supposed to be a marketplace of ideas. Now, is a college campus today actually fulfilling that purpose?
Unfortunately, no. And as crazy as that case sounds, right, someone actually arrested for handing out a copy of the Constitution on their own university campus. We see similar situations playing out all the time. We have cases that we've had just in the past year. We've litigated about 14 different cases in the past year. And they range from things like not just the Constitution case there, but some schools that essentially accomplish the same purpose just without actually arresting students. So North Carolina State University, for example, they had a policy that required everyone to get advance permission 5 days in advance before they could speak anywhere on campus. And of course, the way a policy like that gets applied is that it's not applied to everyone. It gets applied to the Christian student group that wants to share their faith on campus. And so we see these situations playing out every day. And some of these cases we deal with in litigation. Some we're able to resolve these situations through letters because universities know that we're serious and we will sue if we have to in order to defend students' First Amendment rights. But unfortunately, we see these cases playing out all the time, and universities are just not living up to their reputation as a marketplace of ideas that they're supposed to be.
Thanks for that, Casey. Now, Mike, I know you have a long history in education. You started the Homeschool Legal Defense Association. You founded Patrick Henry College, as you mentioned. So what's most unsettling to you about the environment on college campuses today?
Well, it's the desire to coerce people into a particular worldview. Mm-hmm. The Supreme Court in West Virginia versus Barnett case, a case involving flag salute in the school context, said that we cannot have government-installed orthodoxies in matters of religion, politics, nationalism, or other matters of opinion. And yet we see colleges around the country and local governments around the country, to some extent, installing what amounts to a heresy test. That if we don't say exactly the right thing on the college campus, you're going to be punished. And we see presidents of various universities saying it's just not intellectually respectable to be a conservative. Well, that's one thing for them to critique that. It's another thing for them to try to silence their opponents. And we see way too much silencing going on college campuses these days. Absolutely.
Casey, I think I mentioned right at the beginning of the segment that your team has an incredible record of success. Is there a particular case that's coming up that you're excited about, something that you're really focusing on engaging in?
Well, thank you. We do have quite a record of success right now, and that's a tribute to the team and the broader ADF team. We have about 400 wins we've had over the past decade or so. And so a lot of litigation wins, a lot of out-of-court wins as well. I think the case that I'm most excited about coming up is Chike's case, as we refer to it. A young man named Chike Uzabunam at Georgia Gwinnett College, just in suburban Atlanta, to make the point that these things don't just happen in San Francisco and they don't just happen in Boulder, Colorado, and all the places you would expect. Chike decided he wanted to share his faith, went outside to do that outside the library and started just talking to other students about his faith. He was approached by administrators who told him that he wasn't allowed to do that. He had to go to the free speech zone. And so Chike wanted to do whatever he could to make sure he could share the gospel. And so he complied with their demands, went and got his permission 3 days in advance, got his slip that allowed him to go out and share his faith on a tiny patio, the only place he was allowed to talk on his university campus. Went out and did that, and even after going through all of that, complying with all their demands, he just started sharing his faith, and an officer came up and told him that he would have to stop because he had disturbed the peace and tranquility of other students by talking about the gospel. And so that case is pending right now. We're litigating that case against Georgia Gwinnett College in Atlanta, and the school has actually made the argument that if a student is talking about their faith on a university campus, that's tantamount to fighting words, which would mean that you could actually prohibit people from talking about their faith on a university campus, that it would not be protected First Amendment speech at all. That's a really disturbing argument, but it gives you an idea of what's going on in these university campuses and why it matters to all of us. Because if that sort of an argument were to prevail on a university campus, it could restrict the gospel elsewhere. So it's a key case to be able to help us make sure that we are keeping the door open for the spread of the gospel, and make not just on campus, but in our broader culture.
You know, that's a great transition to a question I have for Kristen. So, Kristen, your team is engaged in this. Why is it so important, do you think, to protect freedom on campus and maybe the broader relation to freedom in society?
Well, I mean, as we mentioned earlier, what happens on campus doesn't stay on campus.
Mm-hmm.
The thoughts and beliefs that are taught in there, the subtle, soft totalitarianism ideas, those come out of the campus and they go into the real world and into the marketplace, and that's what we're experiencing right now. Even the Supreme Court has recognized that the intellectual individualism that we have and the rich cultural and spiritual diversity that we have in America, it rests on the idea that we have to give freedom of mind and spirit. And sometimes that comes with eccentricity. Sometimes it comes with statements that are offensive to other people. But that's what it comes with. If we want to have the ability to disagree over things that really matter, like sex, marriage, and religion, then we have to put up with ideas that we might not agree with. It also allows us to explore what is true and not have the government coerce us or not have us have to bend our knee to a government ideology, but gives us the freedom to explore what the meaning of life is and then to live consistent with that.
Absolutely. Thanks, Kristen. That was fantastic. So as I mentioned earlier, this is an interactive town hall, and we do have some time to go to questions right now. In fact, if you would like to ask a question, if something's popped into your head and say, gosh, I'd really like to know about that, just dial *3 on your phone. You'll get through to a representative, and you put you through. So right now, we have Larry calling in from Oregon on the phone, and he has a question. Do we have a plan on approaching hate speech on college campuses? Larry, you there?
Yes, I'm here.
Okay, go ahead with your question.
Yeah, you know, we seem to be the Christian community on campus, and even let's say the conservative in the conservative community on campus are being attacked by well-organized groups to hinder free speech, not only on the speakers in the selection of speakers, and they have to either or forcibly resign from their speaking commitment, or cannot speak whatever topic they're going to speak on by various organized groups, and is what's our plan to, I guess, take it either to the administration or force the administration to adhere to free speech rights on campus, whether it's a religious message or maybe a conservative message that has religious themes.
So, Larry, that's a great question. And the way that I heard it is, what are we doing, or what can be done to maybe open up the idea that all speech should be offered on campus? Because we have seen a shutting down of certain points of view on campuses for a variety of means: protests, people walking out during graduation ceremonies, all means of trying to quiet the maybe a differing point of view. So, what are we doing to engage in that? Casey, actually, you might be the best person to talk to that. What are you doing? What is your team doing to make sure that civil discourse is protected on college campuses?
Sure. Well, I think the very first thing you do is that when universities violate the First Amendment, you sue them. You hold them accountable so that they are aware of the fact that there is going to be a consequence for violating students' First Amendment rights. We have a very close working relationship with basically the organizations that are the ones bringing speakers to campus, with Young Americans for Freedom and with Young Americans for Liberty, College Republicans, a lot of these groups. We have very close working relationships with them so that when these problems happen, when they have speakers that are shut down, we're able to respond. We recently represented Ben Shapiro and Young Americans for Freedom at Cal State Los Angeles, where faculty members decided they would literally lock arms and bar people from getting in to hear Ben Shapiro speak. So first thing we do is we sue, but I think the broader answer to the question is you eliminate a lot of these bad policies that allow these schools the leeway to do what they're doing and to try to exclude speakers they don't like. And so we work before the event has ever happened to try to make sure that these policies are gone so that schools don't have these discriminatory policies that allow them to exclude speakers that they don't want to hear.
Mm-hmm.
Bob, I just wanted to add that the ultimate goal is to get rid of the free speech zones policy.
Sure.
There's a free speech zone. It's called America.
Mm-hmm.
We really should have the freedom to speak wherever we are in this country. And the idea that we're going to shut down college campus free speech, you have to go stand in this little isolated spot. And even then, as we learned in the Georgia case, you may be subject to restrictions. That whole idea that people don't have the ability to shut you down because they're offended. If you can offend, this stuff all offends me. I would shut down 90% of what a professor say in this country if offense to me was the standard, but offense to them shouldn't be the standard either.
Yeah.
Free speech should be able to roll forth.
So, Casey, I know your team is engaged on campuses across the country, but if you were a student, we had a student at Fresno State not too long ago that was dealing with that very same issue. You had a college professor telling her that colleges are not a free speech zone, that it's not something you can engage with, and all she was doing was writing, with permission, some messages on the sidewalk. He asked students to come out and erase those messages. So she was brave. She contacted us, and you represented her. You're doing a great job with that case. Now, if you're a student on a campus, how can they get involved? How can they, maybe recognize one of these challenges, either in a free speech zone, or maybe through viewpoint discrimination and speech codes, or maybe even activity fees, as in the case of Cal State San Marcos? Right. How can a college student get engaged here?
So the first thing I would tell them to do is come to our website. We have information on our website, and reach out to us because, I would encourage students to find out what their own policies are, and we can help them do that, to find out what speech policies that they're existing under on their campuses. What we often find is that for many students, they don't even realize how their free speech rights are being violated. They don't know that if you are being required to submit your literature 5 days in advance before you can go hand it out on a university campus, your free speech rights are already being violated, regardless of whether they approve the literature or not. You can't have the government having to check in and see what you're handing out before you're really allowed to hand things out. So a lot of these violations are already right there in the policies, and so we encourage students to get a better understanding of what's permitted and what's not under the First Amendment, and to be proactive in addressing that. Try to make their campus the kind of place that they want America to be eventually, right? A place where freedom is respected for all students, and that begins right there on your own campus.
Great. And we also have one last question in this segment. We'll get to more later. But right now we have a question. John from Pennsylvania. In fact, I was in Pennsylvania last week. I envy you your weather. We're in Scottsdale, Arizona. It's going to be about 120 degrees here today. So, John, what is your question from Pennsylvania?
What I'm thinking is that ideas, are we willing to suffer for the truth? And it seems like when we have to demand an idea be accepted or acceptable, that we've already lost quite a bit of the impact of the idea.
Well,
Yeah.
The response that comes to mind is the Apostle Paul, when he was denied his rights as a Roman citizen, stood up and demanded his rights. Mm-hmm. And so if there's a context we're in where we don't have the right to, under the regime that we're living, then we got to stand up and say what's right, and we suffer the consequences. But if our rights under our Constitution give us the ability to speak in freedom, we got to do that. We got to do the same thing the Apostle Paul did. He stood up and stood on his rights as a Roman citizen. He said, you can't punish me without a trial. And so he appealed there. And we've got to do the same thing. We've got to stand up for our rights, both procedural rights and substantive rights, and we need to fight back because freedom's worth preserving, and the freedom to preach the gospel is the most important thing of all to preserve.
Absolutely. So thank you for your questions. As I mentioned, We'll have more time for a few questions at the end of this next segment. Your petition and your participation and support is an invaluable part of what we're doing. Casey, again, always great to talk to you. Thank you so much for the work that you're doing, and thanks for being with us this morning.
Absolutely. Thank you, Bob.
Well, we now have the pleasure of welcoming Brianna Koski and Joanna Duca of Brush and Nib Studio.
Good morning.
There you are. Go ahead and you can take a second to get your headphones on.
Good.
So, welcome. How are you guys doing? Thanks for coming with us, being with us this morning.
We're doing good. Yeah. We're
Cool.
glad to be here.
So, tell us a little bit about Brush and Nib Studio. What is it that you guys do?
Well, we are an art studio. So Brianna is a painter and I'm a calligrapher, and we create artwork for events, weddings, special occasions. And that's what we love to do and what we've been doing since we started our business.
Great. Now, so, Kristen, this case has been going on for some time in Phoenix, Arizona. Can you kind of bring people up to speed on it? What's involved here? What's at stake?
Sure. Well, Joanna and Brianna are Christians, and they want to live and create artwork that's consistent with their faith, as millions of other American Christians and people of all faiths want to do. The right to speak and live consistent with your faith is something that we've cherished as Americans, and it's what's at stake in their case. Phoenix has a very common ordinance that we're seeing in other cities as well, and it says that you cannot directly or indirectly make any distinction whatsoever in the availability of services or in any way, in any type of services or goods that you're creating on the basis of sexual orientation, gender identity, or gender expression. There's a second component of the ordinance that's equally troubling, which we refer to it as a publication ban. And it expressly says that not only can you not make a distinction based on your faith, but you also can't say what you think, what your faith is, essentially. The ordinance says that you cannot make any communication, including on your website, that would directly or indirectly cause a request or a person requesting something to feel that the request is unwelcome or undesirable. And of course, those terms aren't defined. And there's a huge, huge stick at the back end of this law. And that is, I think, alarming to all of us, which is they have a $2,500 fine for every day there's a violation, and most importantly, 90 days in jail for every day there's a violation. So in practical terms, what that means is that if a request comes in that they have a religious conviction about not doing, including something that would have to do with same-sex marriage or gender identity, and they politely, kindly decline to do that artwork and create custom art designs, Phoenix is threatening to put them in jail.
That's crazy.
Brianna and Joanna, it's good to see you again. We've had a chance to visit before, and
Yes,
I
good to
know
see you
that
too.
like most artists, I have a son who's a painter, that you bring a lot of passion to your work, and it's
Yes.
infectious, and people really enjoy seeing what you've produced. What is it about your work that brings you the most joy every day?
Well, I think creating artwork that reflects God's creation and beauty, and we pull ideas from nature and architecture, and just basically anything we see that we think is beautiful inspires our art, and everything that's beautiful in the world was created by God. So that's just really fun to put onto paper and get our ideas out there, and we're really attached to what we create, and we love it. So yeah,
It's definitely a part of us. Everything that we put out there.
That's just great to hear. So I know that you've been involved with Alliance Defending Freedom, your case now, for a number of months. What has it meant to you to have Alliance Defending Freedom stand alongside you in this effort? Did you just try to assert your right to live consistent with your beliefs?
Yes, and Alliance Defending Freedom has been a huge blessing to us, a huge support just every step of the way in the, helping us to be able to defend our rights as a business and as Americans, and just in the encouragement and the expertise that they bring, and we've been extremely grateful.
Well, Joanna, Brianna, thank you so much for being with us this morning. Just, our prayers will be with you. We do have time for a few questions. For those listening or watching, if you would like to ask a question of the attorneys here, maybe even of Joanna or Brianna, dial *3. We're taking calls now. We'll have you put through to a representative, and then we'll put you through here on set. So right now, we have a question that's come in from Facebook, and this is for Joanna and Brianna. How did you come up with the name for your business, and what were the hurdles to starting it? I know that there are a lot of hurdles to starting a small business, yeah?
Well, Joanna, I think, thought of the name at first, and we just thought it was an awesome name because it incorporates both of our tools, and we're an art studio, so that's where the studio comes from. So I use a brush and she uses a nib, so it just worked out really good. And I think probably the most hurdles to starting up were just figuring out all the logistics of starting the business, what it takes to file for a business, the taxes, and all of that. But then also what our rights were in creating our artwork and figuring all that out. Because we started with Alliance Defending Freedom not long after we started our business. So,
so this has been ongoing from the time you guys have been in business. But
pretty close.
Pretty close.
Well, I know that me and our team, just thank you so much for standing up for this, because I mean there are a lot of people who might be looking at this and saying, "Gosh, that's daunting. You know, do I want to face all of the consequences that this ordinance offers?" So what advice would you give maybe to a couple of creative professionals who are sitting thinking, "Gosh, should we engage in this? Should we begin a business?" What advice would you give to them?
I would say definitely go for it, because God's given you a talent and a gifting, and you don't want to hold that back or not use what He has given to you. But also be prayerful and wise and realize what's at stake. And definitely I would seek help. I would talk to Alliance Defending Freedom and find out what your rights are, where you live, and how you can run your business consistently with those, or if that's threatened, what you can do about it. And to be proactive, because it affects not just you, but others in the area that you live and throughout our country.
Now, Kristen, I know that what Joanna and Brianna are challenging, or the type of lawsuit that they've filed, is a pre-enforcement challenge. And this is an important type of lawsuit when it comes to civil rights litigation and really establishing people's freedoms in America. They've been used for a long time. Can you tell us about a pre-enforcement challenge, what that brings, and kind of what we're arguing in that case?
Well, I think it's helpful to first understand what I would refer to as our first-generation cases, which many of our ministry friends and others are aware of. Our cases involving Baronel Stutzman, the florist in Washington, or Blaine that we talked about earlier. Those are people that have been sued. They've been presented with the request and have had to refer to someone else. They're defendants in lawsuits. And because they are defendants, everything they own is at risk. For Baronel, her personal assets as well as her business assets. In contrast, a pre-enforcement challenge allows people like Brianna and Joanna to go in proactively and say, "Court, tell us what our rights are. Affirm that not only are these our God-given, but there are constitutional rights to live and work consistent with our beliefs," so that they don't have to face jail time if a customer comes in. But they're asking their rights to be declared in advance, which is exactly what happened in the civil rights movement as well.
All right, so we have another question from a caller. This is Anne from Germantown, and she has just a question regarding government's involvement in maybe even making a decision to serve. Anne, what is your question exactly?
I just don't understand, if you have a private business, you've opened a company, why anybody, the government or anybody else, can tell you who you can service. I mean, if your group wants to take a vacation for a week, they don't have the right to say, "You can't do that because I want to come in and get some business from you." I just don't understand it.
Well, we have entered an era, Anne, where the government thinks it is more of a permission society, that you have to have the government's permission to do pretty much anything. I mean, this process they described about starting up a business. I once saw a bumper sticker that said, "I wish it was as hard to get welfare as it is to start a business." But the idea that the government, there's a branch of fairness laws that are overriding freedom principles. And in some respects, our society has agreed to that. In the area of racial discrimination, we've decided to agree to that. But we're perverting that area into areas where people are absolutely protected by the Constitution in being able to say what they want to say and not being coerced. Coercion to speak is an area where the Constitution should be pretty close to absolute, that no government should ever be able to tell you, you must say this or you may not say that. And so that's what's going on in this case. It's coercion to speak. They have to deliver a message they don't want to deliver, and the government simply can't do that.
And I think that's an important distinction here that you bring up, is that what Joanna and Brianna do, what Barronelle Stutzman does in Washington State, what Blaine Adamson does, what Jack Phillips does, is they convey a message. They use their God-given gifts to help people develop a message and then promote it or express it in some way. And that is somehow different from how it's positioned in the media or maybe those on the other side of these lawsuits. Can you talk to me a little bit about the difference between denying a request to promote a message that directly conflicts with my beliefs and denying to serve someone because of who they are?
Sure, and I'm just going to take it right to the civil rights era, because the most common argument that we hear is, well, this is about someone denying someone who wants isn't in an interracial marriage or wants to discriminate against African Americans. And the Supreme Court has already answered this question. In the Obergefell, the same-sex marriage decision, no matter what you think of that decision, the court said that good and honest people have reasonable beliefs based on religious and philosophical premises that marriage is between a man and a woman. The court's already said that. If you look at the Loving decision, which addressed interracial marriage and the odious nature of white supremacy and what was going on there, the court said exactly that. It is odious. It is based on white supremacy. And those laws, the reason we have a Civil Rights Act is because there was an entire system of laws that were designed and rooted in slavery and to ensure that a system of white supremacy continued. That is not what this is about. Yeah. Our clients love and serve everyone. They're happy to serve customers who identify as LGBT, and they do. Our clients have had a number of employees that identify as LGBT individuals. And in Barronelle Stutzman's case, she served her customer who was identified as gay for nearly 10 years. So it's not because of the fact that they say they're gay. It is because of the message that they're being asked to promote in that particular event. And it's because they are being asked to participate in a religious ceremony, which is sacred to their faith. I mean, it exemplifies the relationship of Christ to his church. There's not much more foundational principle in the Christian or the Catholic faith. So there's a clear distinction between denying someone a hamburger or a job just because of they say that I might be attracted to someone of the same sex, and saying I can't promote this event because it violates my core convictions.
Sure. So, Joanna, Brianna, we've kind of gone down a trail here, but again, thank you so much for being with us, and again, thank you for making the stand that you guys have. And I know that everyone at Alliance Defending Freedom and those who are watching here today, they're going to be praying for you and for your case as things progress.
And Bob, can we just add, for our listeners, I'm sure they're open for business online and would welcome business at Brush and Nib Studio.
Yes, thank you. Thank you for having us.
And I've seen some of the work you guys have done, and it is beautiful.
It is.
It's the way you can take somebody's idea and express it is just astounding.
Thank you.
Absolutely.
Thank you. It's a pleasure to be with you.
Thank you.
Now, for our third segment, we're joined by a final guest, David Cortman, Senior Counsel for Alliance Defending Freedom and Vice President of U.S. Litigation. Now, in April, David was actually in front of the Supreme Court arguing on behalf of Trinity Lutheran Church of Columbia. Now, David, welcome to the set. Welcome to the show.
Thanks for having me. Good to be here.
And to Phoenix. So, David, for listeners who maybe haven't been following the case to date, and I don't know how they haven't, if they are listening on or watching on our Facebook page, but if they haven't, can you bring them up to speed? What's gone on in this case till now?
It's a great case. It's funny. It's about playgrounds for children, but yet it carries an extremely important constitutional issue, and that is, how can people of faith or religious organizations be treated by the government? Can the government discriminate against religious organizations or individuals that are religious solely because of their religious status? And so what's neat about this case is we have this Trinity Lutheran Child Learning Center. They have a preschool. It's run according to their beliefs. And the state of Missouri has this grant program, and it's a pretty good program. They recycle scrap tires, so it gets out of the landfills and out of the rivers and the waterways. And what they do is they recycle them, and you apply for a reimbursement grant. So all preschools, not-for-profits who have playgrounds are allowed to fill out this complicated application, has all these different steps and criteria, and then they grade those. Well, Trinity Lutheran got a high enough grade to be awarded a grant for that year, but once the government realized that it was affiliated with a church, they said, no, you're prohibited from receiving this reimbursement grant solely because of your religious status, and that's what we went to court about.
Now, so Mike, this was the first case that Alliance Defending Freedom has had before the Supreme Court since you've been our CEO. Right. But I know that you actually have argued cases before the High Court. Just from your expert opinion, you were in the courtroom. How did things go? I mean, you saw what the justices were asking. How did it go?
Well, it went very well.
Uh-huh.
Dave did a great job. He was fantastic. The attorney for the state of Missouri, not so good. I've been a moot court coach, and he wouldn't have made my team.
Mm-hmm.
But at one point, I thought the best lawyer in the courtroom for us was Elena Kagan. Justice Kagan started arguing our position.
I'll try not to take any offense to that.
Well, just for a moment, okay? I knew that we were doing well, but once she started arguing our position, I go, okay, we won. Now the question, we're waiting for the opinion, so it's educated guessing, but I'm pretty certain of the educated guess. Whether it's going to be a broad victory or a narrow victory remains to be seen, but I'm fully expecting a victory in this case.
Well, David, I mean, you're so involved in this case. What are the possible outcomes here? What are the scenarios for Trinity Lutheran?
I'm going with Mike on this one.
Okay.
No, and it is a really good point, because what happened was the case was granted to be heard by the Supreme Court well over a year ago. And then we lost Justice Scalia, which was certainly a tragedy. And so we thought, well, the court will rule on the case. We thought we'd still be able to win. Really should get all 9 justices, but maybe even at that point a 6-2. Well, they held the case for about a year, so we thought, well, what's going on? Everybody was prognosticating, is this going to be a 4-4 split? We never thought it was until they held the case for about a year. So when we went to court, and as Mike was saying, when you have Justice Kagan and Justice Breyer asking more difficult questions of the other side and saying things like to the other attorney, this is probably one of the most important constitutional principles there is, that you can't discriminate against people of faith solely based on their religious status. Isn't that prohibited? And I thought, well, that's a great question. There's really no good answer to that. And so we're hoping for at least a 7-2 victory if we got the questions right. But the principle is really more important, and that is in the way government is involved in seemingly everything these days. Mm. And so when they give government benefits, which applies to almost everyone, can they say, just because a person is a person of faith or an organization is a religious organization, can they discriminate against you and prohibit you from applying on the same basis as everyone else solely because of your religious status? So that's an extremely important principle that we're looking forward to a good opinion on that.
Okay. Now, Kristen, Dave mentioned this, and I think it was on everybody at Alliance Defending Freedom. It was all on our radar, because the court accepted the case, and then we waited and waited and waited. But it allowed, I think, a lot of us, for us to really get our minds around what this case actually meant. But I really want to hear from you. What did this case mean to you and Alliance Defending Freedom?
Well, I think there are a couple things that it means to us, and Dave has already said many of them, but primarily, can you be discriminated against because you're religious? I mean, on its face, the law specifically excluded these people because they were a church, and that's just wrong. So having a decision, whether it's broad or narrow, that says you can't do that. You can't tell people that they're eliminated from a government program that provides neutral benefits just because of their faith. That's going to be critical to moving forward in our case law. I would also say that a child's knee, whether that child is on the playground of a secular playground or on a religious one, is just as bruised and battered and cut by having an unsafe playground surface. And so as we were batting around, what does this case mean? Think about the implications if the court were to have ruled against us. Would a church or a parish be ineligible for receiving fire protection or police protection or other government programs that are essential to their safety that everyone else can have, simply because they are a religious institution? That's what's at stake here. And we should say that the state's argument was, well, it's the Establishment Clause. It's our state constitution, separation of church and state, which is not in the Constitution. That's what they were arguing. And so a victory here will say, no, you can't use the false notion of separation in church and state to come against and exclude people of faith.
So, David, You've argued before the Supreme Court before, I think most recently in Reed v. Gilbert, which was a great win for Alliance Defending Freedom, and for Pastor Reed over in Gilbert, Arizona. Was there any difference, I think, when you appeared before the court between then and now? What was your experience between the Reed case and this case, maybe?
It was the difficult part was waiting so long, and the reason for that is when, as Mike knows, when you get a Supreme Court case, you dig right in, you kind of clear everything else, and you dive into it for a couple of months or weeks, whatever you have. Well, this went on for so long, you push it aside, then 2 months later you pull it back, and you're still working on all your other cases. So the fact that it was extended out that long was difficult because you didn't know how much to prepare and when, or how much notice you were going to get. But I think that the good part of it was, you're being, whenever you do something more than once, you get a little bit more familiar with the process. You know what to expect. So it was one of those things where, since I had done it once before, I was kind of able to come in knowing what to expect. We're still nervous. I'm always nervous when I go to court. We're still nervous, but knowing what was coming made it a little bit easier the second time.
All right. Well, actually, we have two Supreme Court litigators here today. What is involved in getting ready for a Supreme Court case like that? You don't always get that amount of time that you had for Trinity Lutheran, but there's a tremendous amount of information that you have to consume, understand, and then be able to respond to in different ways. How do you prepare?
Well, the goal is to synthesize a fairly extensive record and a whole body of case law, have it at your fingertips, and be able to give succinct answers that are fair representations of the case law and the facts. So it's taking a mountain of information and making it understandable in a succinct fashion. So it's a hard work. It's easier to talk long than it is to talk short, and so you have to talk short there in that context.
Mm-hmm. And what was interesting about that is one of the first questions I received from Justice Ginsburg was a quote from a case from 1947. Mm-hmm. And I'm not sure if her law clerks dug it up and said, you can get him on this one. He'll never have read that case because it's so old. But you have to know the case, which we did, and be able to respond very quickly. And it kind of cut off that line of questioning. What's great about ADF is you have an entire team around you. So it's not just you. There were 75 memos done about all the issues, synthesizing cases, pulling up cases, research, moot courts, all the development, everything that's done. And so what's nice is you're not going it alone. Mm-hmm. You have an entire team around you, and that makes the preparation so much better when you're going through it.
And Kristen, you were in front of the Washington State Supreme Court just November of last year with Barronell's case. And what I remember about that was that, you worked, I know, up to the last minute and in your open and putting it together in just the right way as you went through those moot courts and refining it and getting it better and better. How much of your open did you get out before justices started interrupting you and you had to start responding to those justices?
Well, I actually got out more than what I thought I would get out. I got through some hypotheticals that were important to me to square up the issue for the court. One of those hypotheticals is whether a Democratic speechwriter could be forced to write for Donald Trump, which is at issue in many of the cases we're talking about. It extends much more broadly even beyond religious faith. So I think I got maybe 30 seconds in. But with that court, where we knew all 9 justices were against us, I was thinking maybe 15 seconds at the most.
Wow. And it is. You don't know where the next question is coming from, correct? It could be from any of the justices, but there's a pecking order, correct? And the justices kind of cede to each other?
They do, and it's based on seniority. So it's not who speaks first, it's whichever is the most senior justice, in that case, asking the question. And what's interesting about that is at the United States Supreme Court, you are so close to the justices. You're less than 10 feet away.
Really?
And so you cannot see all of them at the same time, all 9 of them. You actually have to scan back and forth to see who's asking the question, which side are they on. You always want to make eye contact with the justice that's asking the question. But once you start answering the question, then you want to go back to looking at everybody else to make sure that you're talking to the whole court. So it's interesting how the dynamics of it works.
All right, we do have time for some more questions from callers. Right now we have Karen from Nebraska on the phone. She has a question actually about when we might extract Trinity Lutheran ruling. Karen, go ahead with your question.
Well, thank you, and I just so appreciate all the work that ADF does to protect our religious liberty. Question is simple. When do you expect the justices Supreme Court to render their decision on the Faith Lutheran case?
It's probably going to be the last day of the term. which may be extended. So what happens is when the court gets near the end of the term, they have to issue all the opinions from the cases they've heard before they get to go on summer recess. I guess maybe it's their punishment or whatever it happens to be. So the last day of the term is Monday, the 29th. But my guess is they're going to extend that term to 26, actually. They're going to extend that probably a couple of days. So my guess will be the last day of the term, wherever that falls.
All right, and remember, if you'd like to ask a question right now, dial *3. They'll put you through to a representative. They'll get your question on air here shortly. In fact, right now we have one, Brad from Iowa. He has a question about Alliance Defending Freedom engaging, actually, in religious freedom battles and some key states that are doing that. Brad, what's your question? Go ahead.
Yes, appreciate all you folks do for religious freedom. And I wanted to kind of address the current state, where things are in the legislatures in the states, of course, with the rollback of H2 in North Carolina, and then HB 15, I think it was 32 or 23 down in Mississippi that got put on hold. Are you folks, do you sense that we're making any progress? My sense as a pastor is that we're making progress in the life issues across the country, but the GLBT has essentially, those who are promoting that agenda, because they've been able to access the business environment, have been able to really bring legislation to a screeching halt as far as RFRAs or anything similar to a RFRA. I just seen it. Is that a correct assessment, incorrect assessment? I'd be happy to have it incorrect. But where do you sense we are, and is there any exemplary state where things are really moving forward right now?
Kristen, go ahead.
Well, I would say there's good news and bad news. I think you've correctly assessed that laws like RFRAs are hard. It's hard to get those passed right now. They're being mischaracterized, but it's a season, and that's what law and making law is about. Is we live through seasons, and so we expect that to be a temporary period. I will say that on the Mississippi law, though, for example, that's before the Fifth Circuit right now, and we're counsel of record in that case, and we expect a win in that case. We're waiting. We're hopeful. In addition, when you talk about the North Carolina and really the locker room issue, that's where a lot of the legislation has been focused lately on whether people of the opposite sex can go into locker rooms and intimate facilities of the opposite sex. And while we faced an onslaught largely through the Obama administration and in that time period, we are seeing rollbacks. We have a number of cases we're litigating in that area and model privacy bills that we do expect to continue to be run throughout the United States. So there's much to be optimistic about, and we have an entire team that's focused on providing legislative support in these areas. And I want to add that I think the media mischaracterizes what's happening. Did you know that there hasn't been one SOGI, one sexual orientation, gender identity, non-discrimination law passed in a state since 2009? We were able to defeat bills in 7 states last year alone, as well as in a number of major cities. So when you hear cases about like Brush and Nib and Joanna and Brianna or the Flores Barronell, we're able to use those examples to show these laws are not necessary, and they're actually being used as swords, as weapons against people of faith. And that's helping us turn the corner on these legislative issues.
And actually, that's a great transition to the next question. Mary from Texas has a question about Barronell's case. Mary, go ahead. Mary,
status of the Barronell case right now.
I'm sorry, are you asking about the status of the Barronell case?
Yes, where is it, and what are we waiting for?
All right. Kristen?
Well, I reviewed a brief this morning. We're in the midst of writing our petition to the United States Supreme Court, and we will file that on July 14th. Then the other side will have an opportunity to respond, and we expect the court to decide whether it will hear Barronell's case in the fall term.
Great. So, David, thank you so much for being with us this morning. Mike, Kristen, thank you so much as well. And everyone, thank you so much for calling in. Today, we've heard about some of the most pressing issues facing religious freedom in America today. Kristen, do you have any final thoughts for our listeners?
I do. I would focus on two pieces that I don't think we think broadly enough about religious freedom or why it's important. And so I would encourage people to think about it, think about two primary components. One is that religious freedom is for everyone. It's not just for a certain faith, because it gives all of us the ability to explore the meaning of life and then to live consistent with the answers we find. And that's as true for the atheist as it is for the Protestant or the Catholic or the Hindu or the Sikh. A second thing that I think most people don't realize is that civil liberties travel together. And what that means is sometimes we'll hear, well, people of religion have done bad things. Well, if you actually look at the history of nations, you'll find that there's more poverty, there's more violence, there's more war in countries that do not have religious freedom. And those countries that protect religious freedom most broadly have vibrant democracy. They treat the vulnerable much better and they protect them. They have broader economic liberty and broader freedom of the press. So no matter what you think about marriage or what you might think of a particular position, you do want to stand for religious freedom because it protects everyone and it protects all kinds of civil liberties. If we lose religious freedom, we will lose our other civil liberties, and history tells us that.
Now, Mike, how can those people who've been watching and listening today, how can they stand with us?
Well, they can start by praying. I don't say this because it's a perfunctory thing that Christians are supposed to do, or are supposed to say especially. But I have seen God answer prayer in the courtroom. I've seen God answer prayer in the legislature. So it's not just Bible stories that I believe, and they really happened, but it's stories I've seen in my own life. I've seen God move in these areas. So please pray. Pray specifically, pray often. They can help us financially. All this litigation costs a lot of money. The Barronell case, for example, we're at the Supreme Court level. It's going to cost even more money as it goes on. So giving to us allows us to keep fighting all these fights, fighting for the university, fighting for Trinity Lutheran, all of these cases. And one thing I would say, rather than giving money to your alma mater, I think all people who believe in freedom should say, I'm not giving to my alma mater anymore until they adopt a freedom position. And write a letter to your alma mater and tell them that you're stopping for right now. And once they get freedom back on the floor, then maybe we'll consider it again. But that would be one thing I would really urge people to think through.
Again, thank you so much for taking time out of your day to join us on this town hall. I just can't tell you how much I appreciate it. It's just been a great discussion. I know everybody will have appreciated it. So again, we hope that you've enjoyed the show today. Alliance Defending Freedom is a nonprofit legal ministry that's supported by people who value freedom just like you. Your support allows Alliance Defending Freedom to represent those who are standing in the breach. College students at the center who are involved in the Center for Academic Freedom cases, small business owners like Joanna and Brianna, and even small town churches whose fight goes all the way to the Supreme Court. And we do all of that at no cost to those clients. Now, if you'd like to give to support those who are fighting this fight, press *0 to be transferred to a representative, or visit adflegal.org/townhall. That's adflegal.org/townhall. Again, thank you for joining us today. We value your partnership and participation in our show and in our organization. We look forward to future town hall events. Thanks and God bless.